Good evening, everyone. I am Shannon Davis. I am the founder of MYV Law Firm, where we endeavor to educate, to empower, to enable, and to equip you to turn up the volume on your legal interests, that is, to maximize your voice. We are located in the Central Florida area, but we are a virtual firm and able to practice in several different jurisdictions with some of our practice areas, specifically with copyright and trademark, which follow federal law, and we can handle those throughout the United States. So tonight, the goal is for us to discuss structuring your biz, protecting your biz, and then maximizing your biz. And what we do at MYV Law Firm is we practice in the areas of business, entertainment, real estate. We also provide mediation services, and we've got a title division. One of, again, our main practice areas is business law. And in that business law practice area, it's important for us to educate our clients on, first and foremost, structuring your biz, your business. How do you set it up? What do you need to set it up? Where do you even get started? I have a lot of people that come to me and ask, or I've even seen a lot of people on social media say, okay, well, all I have to do is register my LLC, which is a limited liability company, and I'm good to go. Once I register it with the state, I've started my business. There's nothing else that I need to do. I'm good to go. I'm here to tell you that if you want to structure a business, and the goal is not just to register with the state, but first you need to determine what your structure should be. There are several different types of business entities, several different types of ways that you can operate a business. A limited liability company is one of them. I will say it's one that's more favorable because it kind of gives you the opportunity to join together the corporation and a partnership. It has the flexibility of a partnership or a sole proprietorship, but then allows you the limitation and liability that a corporation has. A corporation essentially is an organization. It is a structured organization that has, it's got shares. And so owners have shares, they own a piece of that business, and then they put people out in front, the officers and the directors, to run that business. Instead of having shares, a limited liability company has membership units. But again, owners own those membership units, and they either decide if they're going to be member managed, where they manage that business by the people who own it, or manager managed, so that they choose someone to put ahead of them to run the business. With partnerships, usually those partners that work together, that own a piece of the pie together, are also the ones that are running the business. And then oftentimes what we really see people doing is a sole proprietorship. And that's where we say, okay, look, I've got a business idea. I'm open to that business idea. I want to be able to put it out to the public. However, I don't have a business structure. So I'm just working by myself, or I've registered a fictitious name, but still I am the owner of that fictitious name. A sole proprietorship is something that I tell people to never do unless this is your hobby, which even if it's your hobby, you might want to structure a business so you can limit your liability. I don't believe that it's important, or I believe that it's too important, right, to not structure that business and not protect yourself. And a sole proprietorship will never protect you. I will say really quickly, one of the things that Brandon said before we got started is that we would be answering any questions. I don't know how those questions come in. I don't know if you raise your hand. I don't know what you do, but if you have questions for me, if you want me to stop, I really would like for this to be a discussion. I got a lot of information that I can give, but if there's something specific that you'd like to know about structuring your biz, about protecting it, about maximizing it, stop me. Give me the opportunity to give that information to you. So again, I'll jump back into the whole idea of structuring a business, and we're looking at entity selection. So one, like I said, the sole proprietorship, I don't believe that you should select a sole proprietorship as your business entity, okay? You should make a choice between a corporation, between a limited liability company, or a partnership. And I honestly believe that typically, if you're going to be doing regular business, day-to-day business, whether you're providing goods or services, a partnership isn't necessarily the way to go. There are some instances where a partnership is a good way to have a business structure, but most of the time we're going to be toggling between a corporation and between a limited liability company. And like I said before, that corporation has got shareholders. It's got the people who are shareholders, they own pieces of the business, but they don't necessarily run the business. And so what we see with small businesses oftentimes is we are not just the owners, but we're also the operators of the business. And where that can get us in trouble is if we own and operate our businesses, then we could be positioning ourselves if we have not structured a business properly. So the goal in structuring that business is to make sure that your personal assets are always protected. Once you select an entity, once you decide if I want a corporation, I want an LLC, I like a partnership, I might want a business trust, and that is a whole different monster. But once you decide what type of entity you would like to run and manage your business, then you need to structure that business. That being, not only do you register, so if you're going to have a corporation, you need to register your articles of incorporation with the state. If you have a limited liability company, you're going to register your articles of organization with the state. So what people normally are doing is going, and let me give you a resource. So, we practice in the state of Florida with regards to business law. One of the ways that you can go on to register is by going to sunbiz.org. Sunbiz.org allows you to choose what business you'd like to register. It allows you to choose a name if that name's not already been taken. I will tell you that the state of Florida does not allow you to register a business that is the same exact name as someone else's. But if you go to sunbiz.org, not only does it have a lot of information on how you can register businesses, but it allows you to register online. One of the only times I will tell people not to register online and to send in their articles of organization or your articles of incorporation is if you have a specific type of business where your language needs to be longer than the number of characters that Sunbiz allows you to input. And if so, then you can just draft your articles and mail them in with a check for that payment. So anyway, through Sunbiz, you can register the business. You only have to register the organizing document, which is your articles of incorporation and or depending on what type of business, the articles of organization. I just got a hello from Sabrina Morris. Hello, Sabrina Morris. How are you? But once you register that business, then you've got a couple of other moves that you need to make. And as a matter of fact, I believe that you should be having meetings and discovering how you want your organizational documents to be prior to registering the business. However, for a corporation, you will have bylaws. Those bylaws determine how your business is ran. And then you'll have a shareholder agreement. And that shareholder agreement is going to determine how your shares are manipulated. And so, as I said before, a corporation has shares and shareholders, right? A limited liability company has members and membership units. You've got two documents that you need for a corporation. You most definitely need the bylaws and you need a shareholder agreement. For a limited liability company, you need an operating agreement. The operating agreement essentially takes a corporation's bylaws and shareholder agreement and joins them together and creates one document that essentially explains not only how that limited liability company is going to be managed and operated, but how the membership units will be manipulated, meaning how can you sell your membership interest? Can you sell your membership interest, or do you have to give it back to the organization? Who can you sell that membership interest to? There are some businesses that are structured specifically for certain fields. And so, for instance, a law firm. NYV Law is a law firm in the state of Florida. No one can have ownership interest in a law firm except they be a lawyer. And there are some other professions that the state of Florida has a requirement for, whereby if you are not in that profession, if you're not a licensed professional, then you are not allowed to have ownership in that particular business. And so with the state of Florida, when we submit our bylaws, and also our shareholder agreement and again, we're not submitting them to the state, we're submitting them essentially to the company. So when we draft those documents and hold them for the company in either a corporate book or electronically, then if you have one of those types of organizations that you kind of can't have anyone else own, you want to have that language in your shareholder agreement and in your bylaws. You want to say that no one will be able to sell their shares to someone who's not licensed in that field. Because if you don't have it in your shareholder agreement and someone wants to sell, they can try to make an argument that they can sell an interest without that person having any licensing requirements. And then you'll position yourself so that your business can be shut down. So I'd advise not to do that. Okay, so I've kind of gotten a little bit into the structuring of the business, where I said you're going to have some organizational documents. With a corporation, there's a lot more regulation than what we have with limited liability companies. And so a corporation is going to require that you have an organizational meeting. It's going to require that you have an annual meeting. And for those meetings, you need to have minutes. And those minutes need to be documentation that shows who was at the meeting, who called the meeting, what happened at the meeting, what was resolved by the board or by whomever was there and able to make decisions. Though a limited liability company doesn't require the same type of regulation, the same type of structure, I advise that if you're going to have business meetings, if you're going to make decisions on what's going on in the business, and it's going to be with any officers, directors, or managers, then you should always have a paper trail. Always have, whether it's going to be, like I said, in a binder, written down. If you're going to have it electronically, you need to have that paper trail. In the event that you ever have an audit, in the event that you're seeking to get monies, investors want to know not only how you structure your business, but how you run it. And you show how you structure and how you run that business by showing what your documentation is and whether or not it's in good order. Again, if you've got any questions, stop me. Give me the opportunity to answer those questions for you. So we're talking about the entity selection, then entity setup, and then those organizing documents. And those organizing documents, again, are going to be the documents that say how your business is ran and how it's operated. Once you've got your organizing documents drafted, everybody signed on to them, and you've put them in a safe place, then it helps you to know what you can and cannot do in that business. Understand that the reason that we structure businesses is to limit our own personal liability. That's one of the purposes. One of the main purposes is to say that if anything happens, I would like to give these goods. I would like to give these services to the masses. But if anything happens and something goes wrong in me providing those goods and or services, I want to be protected. Meaning, I don't want someone to be able to sue me and take my house. I don't want someone to be able to sue me and then take my car. I don't want someone to be able to come after any investments that I have or any interest that I have otherwise. And the best way, right, to sort of shield yourself from that, first and foremost, is the entity structure. If you don't structure your entity, if you are a sole proprietor, then you're essentially out there by yourself saying, hey, I'm right here. If anything goes wrong, come for me. Take the clothes off my back. But that's not what we want to happen. And how we stop that is by structuring our business. Now, after your business is structured, you want to make sure that you protect it, right? So it's not just that you create that business entity, that you set it up, that you make sure you have your organizational documents in place, which, by the way, I did kind of skip a step. One of the reasons we have an operating agreement or bylaws is because the state of Florida has law on how businesses can be ran. However, we run up against certain issues, and I'll tell you one specifically. A limited liability company, the laws pertaining to a limited liability company, the statutes, Florida statutes that talk about how limited liability companies can be ran and what you can and can't do, doesn't have any language in it currently that tells us what can happen in the event that one member no longer wants to be a part of the organization, or a member wants to get rid of another member for something, for some wrongdoing, and they want to remove them from the organization. It essentially requires that that entire organization is dissolved. And the only reason that it requires that is because it says if you can't work together, then let's break up the business, break up the assets, go your separate ways. But if you've got a 15-year-old business and you've got someone that's done some wrongdoing in that business, you want to be able to remove them from either being a manager or being a member without having to dissolve the entire business, without having to start from scratch, right? Because if you've got to start from scratch, anything that you had with regards to your credit worthiness, anything that you had with regards to your goodwill amongst the community, anything that you have been able to build up with regards to your branding, all of that is essentially goes away because you have to start from scratch. And so if you put some language in that operating agreement, if you put some language in the bylaws that says how you're able to remove managers, that would be for an LLC, and then how you might be able to remove directors and officers in a corporation, then you don't necessarily have to just go by what the law says and break that business all the way down, but you can continue to operate as long as you've delineated some steps that need to be taken in order to remove them. And there are several other things that are not in the laws that it kind of leave that up to the people who create those businesses and run those businesses to decide how you want it to be done. But if you don't decide, you're kind of messing yourself up. I see, I just saw a comment, and Brandon, I can't see the comments very clearly when they come up, when they pop up. So if you'll tell me what they say, or I don't know if people are able to unmute and give their comments, but
yes, I can tell you what they say, but also the comments from Benjamin Young. Feel free to speak and join the conversation and dialogue with Attorney Davis. But the comment was that essentially sounds like a business divorce with the prenup.
it is. And you know what? What's crazy is that, a lot of people don't want to get into, you don't want to get into business thinking about the end of it. Just like people don't want to get into marriage thinking about the end of it. And that's why there's such a taboo, right, on a prenup, right? But if more people sign prenups, I don't think people would be getting married so hastily. And I also don't think they would be getting divorced as much. We're going to leave that for another time. I try to stay away from family law. Let's get back to the business. Business is, when you get into business, it is a marriage. You are joining together to create, right, this entity, and that entity is your sort of joining together in marriage. And so when you break that up, if you're going to break that up, you want to be able to have some things in writing that say how you break it up. Because again, you don't want the state to tell you, the law is ever changing, and you don't want the state to tell you or not tell you how you break up your assets, whether or not someone can continue to use the business name, whether or not someone can continue to use that location. Can you continue to put yourself out there and say that you're a part of that business? There's so many things that you might want to be able to limit or to be able to control. And you can't control those things if you don't have certain things in writing at the onset. And if you don't have them in writing at the onset, I think it's a lot more difficult to get everybody on board to say, okay, well, 6 months down the line or 6 years down the line, listen, we forgot to do an operating agreement. How is our business going to be ran? I think we do it in the beginning, so we don't have any. And then if you do need to come and review the operating agreement that you created, it's a lot easier to go and say, okay, let's go into Article 1, Section 15, instead of let's start this thing from scratch, this 18 to 22 page document. We don't want to do that. The goal is to try to get up front, get ahead of it. So having those things in place, having the documents in place will help you so that you don't end up in a place that you've got to, follow whatever the law is at that time. If you decide to break up, but it's not just about breaking up. It's about in the operating agreement, you might want to be able to say who can sign for checks. You might want to be able to say if someone can sign for checks, at what point do two people need to sign for checks? So for instance, if you've got checks, right, and you want to be able, and not just, signing actual physical checks, but who can take monies out of the business account. Does that have to be an officer, like a president, a secretary, a treasurer, or a manager if it's a limited liability company? If it doesn't have to be an officer, then can it be a member of the limited liability company? And if it's a member of the limited liability company that's able to do so, that would be in a member managed LLC. But whoever is able to take those monies out, you can also put in the operating agreement and or the bylaws, at what point do they need to have an additional signature? Is it at a $10,000? Is it at $100,000? When do you need to say there needs to be some oversight over this particular individual that's taking out monies or that's signing checks? Businesses are allowed to purchase real estate. Who can sign for the purchase of real estate? Do you want to have one signature or two? Are you wanting there to be some sort of checks and balances? When you don't have those checks and balances in place, right, then again, you have to go by what the law says. I did see Kyla's quick question, which was, how often can you change the bylaws? The bylaws can be amended as often as your board of directors amend them. But again, one of the things that I was telling you, it's like, for instance, if you've got an employment agreement, if you've got an independent contractor agreement, if you have a services agreement, if it's working for some people, they're not going to want to change it. So the whole goal is to make sure that you get it right in the beginning. And sure, you can make as many changes as everybody agrees to make. If you're working your business and you see, oh, well, this doesn't work anymore. This doesn't work for us. Let's come together and try to see if we can make those changes. In a corporation, when you're going to change bylaws, that has to be done by a vote of your board of directors. And so you're going to have a meeting of the board of directors. You're going to have to essentially bring it up to say that we want to change the bylaws. And not only do we want to change the bylaws, you need to propose those changes to the bylaws, and they need to be able to vote on those changes. Or you might have a meeting and say, by the next meeting, we're going to have a certain number of people that have proposed language to change the bylaws. And so you can change them as often as needed. It's just, you want to be able to have, as best as you can, that structure in place at the beginning. One thing that I think is important is, because you asked that question about the bylaws, like I said, annual meetings are a requirement for corporations. And because annual meetings are a requirement, then that's one of the things that you can bring up at the annual meetings. Are we going to continue to move forward with the bylaws as is? Or are there some changes that we need to make because we've seen some things differently? I will say, for instance, there's something, and I use a law firm, for example, because that's the business that I run. So there was some chatter going around where the people who are not lawyers, they wanted to be able to change the law so that people who are not lawyers are able to have ownership in a law firm. In that instance, our bylaws that we already created for our firm would have to change. Our shareholder agreement would have to change because it's no longer good law, right? So if the law changes and says that we can now bring on owners that are not lawyers, then the language that I have in my bylaws, the language that I have in my shareholder agreement that says the only people you can sell to are lawyers needs to go away. And so we would have to have a meeting with our board of directors, and we would have to vote on removing that language from the bylaws and amending and restating some of the language that's already in them. Does anyone have any questions before I move forward with protecting your biz? Because we've talked about structuring your biz. I'm going to kind of push us over to protecting your biz. If you've got any questions on structure, now's the time to ask them.
Yes, I have a question.
Great. I'm going to sip tea. Go ahead.
Oh man, don't do that. So my question is, how do you structure a business to own and operate another business? And how do you sell it off if you need to?
Oof. Okay. You want to know how you can structure a business to own and operate another business, and how do you sell off what? What do you want? You want to sell off the business that you structured as the owner and operator?
Let's say I want the company to own multiple companies. and then someone approaches me to buy one of the companies that is under the umbrella, so to speak. How does that process work with selling it off? High overview. I know this is what you do, so we don't want you to give all the tea. But how does that look?
Okay, so I love this question because it kind of gives us the opportunity to kind of dive into things that a lot of people are doing. Sometimes you've got a lot of different ventures that you're getting into. You might have an investment company. You might have a company that provides services. You might have another company that provides products. And all of these companies are owned and operated by the same individuals, or may have an affiliation with one another or some sort of thread. And that main thread is that you want them really to all be owned and operated by the same organization. So that's, like you said, an umbrella or a conglomerate, or what you do is the holding company, or the company that's holding all of those businesses, that owns all of those businesses, would essentially have, and they would either have majority or 100% ownership interest. So for instance, in an LLC, that organization would be a member of the LLC. Okay. And as a member, it would have an ownership interest. If it's a manager managed LLC, that organization would also need to be a manager of the LLC in order to manage that company. Okay. And it could be the member and manager of several different limited liability companies. One of the big things that I think needs to be done, and this is something that you do in business anyway. And so I'm going to jump into protecting and kind of jump back out of it, because when you're protecting yourself and your business, you don't commingle your funds, right? So you don't want to have a business account where you're putting your personal money into it all the time, or a personal account that you're putting your business money into it all the time. If you are going to put monies into your business account, that capital that you're putting into the business account should either be proportionate to your interest in the business, should be a loan to the business. You know, it should not just be you just dumping money into it. Because again, you look like you get to a point where you're commingling your funds, and vice versa. You don't want your business monies. If someone's paying you for a business matter, you don't want them to pay you personally, because when you commingle to that point, there is no separation between you and the business. And because there's no separation between you and the business, that point of liability that you gave yourself, putting that business out in front of you to protect you, in the event that something goes wrong, you essentially just removed it. You got rid of your safety blanket. But the same thing goes when a business owns and operates other businesses. You don't want to have the commingling of funds. So you've got 4 businesses underneath that are owned by one organization. Each of those businesses should have their own accounts, right? They should have their own set of operating agreements, and or depending on if they are a corporation or an LLC, their own bylaws, right? Their own shareholder agreement. And yes, those bylaws and shareholder agreements can mirror one another. They can also mirror that holding company or that main umbrella of the one that owns all those other companies. However, you want to make sure that they are separate entities altogether. And with them being those separate entities, it makes it a lot easier if you're looking to sell one of those entities off. When you sell a business, you have to go through a due diligence process, right? You have to allow for the person who's buying that business to have the opportunity to look at your books. They're going to look at 3 years tax returns. They're going to be looking at whether or not you have any contracts that are unexpired. They're going to be looking at whether or not you've got any equipment. If you've got equipment, what's the depreciated value of that equipment? What's in your bank account, right? If you're wanting to sell off one of those businesses and you've commingled all the funds, then it could either make it look like the business that you're selling is more valuable than it is, or that it's less valuable than it is. And regardless, you find your other businesses are going to end up sharing some liability with that business in the event that, for instance, say you've been commingling all your funds, you want to sell off one business, you'd like to sell that business for two, and I like to use kind of round numbers as best as I can. So you've got 4 businesses that are worth $1 million altogether, right? You want to sell one for $250,000. You've already been commingling all the funds. You're sharing your resources. You're sharing your employees. You've only got one agreement between the 4 businesses, so you don't have anything separated out enough to be able to show exactly what one business is doing. Then, and you want to sell it for $250,000, but what you later find out once you sell it off for the $250,000 is the 3 businesses that are left only make $500,000 a year. And it's because that business was actually making more money, or that business may have had more assets with regards to its human capital, and your human capital is your human resources, your employees, your independent contractors. It might have been more valuable than you were able to place value on it because you just split it between the 4 and said each one of them is worth $250,000, but you did not actually set up separate structures for each one of them. So the main thing is to make sure that you have separately structured businesses, that you have essentially everyone in their own little, compartment. And even though you're going to have one business that might own and manage all 4, that one that owns and manages all 4 can easily sell off one of those businesses when that business is a whole business by itself and it's not codependent on the others. Because if it's codependent, it's not necessarily a business. It might be a division of one organization and not a whole and not a separate business. Did that answer your question?
Yes, it did. Thank you.
Okay. Any other questions? And I think you guys are able to unmute. So if you have any other questions, go ahead and unmute, ask me what you like. If not, I'm going to jump into protecting your business. I did say a little bit about about not commingling funds, but I'm going to go ahead and jump into the rest of it. I think one of the first things that I tell people when I explain to anyone in consultation, and we're talking about creating a business entity, I always tell them, hey, listen, the business stands out in front of you. So you are this little person who decided that, or big person, whatever, you're a person who decided that you wanted to start this business. And in order to do so and do so well, you want to be protected. And to protect yourself, you put the entity out in front of you. That's why you have a limited liability company. It limits your individual liability. Corporation does the same thing, limits your individual liability. So the business is out in front of you. In the event that something comes at you, you've got a business standing out in front of you. What I tell people is, yes, the business stands out in front of you, but you want insurance to stand out in front of that business. And so getting a general liability policy for your general business, day-to-day operations. If something is to happen, then if someone happens to have a claim against the business, then that claim can go through the insurance company first. And then if the insurance company pays out and there aren't any monies, and they pay out everything that they've got with regards to the policy, and there's a deficiency, then the business and its assets would be looking to cover that deficiency, and it still wouldn't touch you because the business has stood out in front of you and insurance has stood out in front of the business. And I will say you can take a step further and not just get general liability insurance, but if you get an umbrella policy, that covers what the general liability insurance won't cover. Right? So some things that are outside. So for instance, if you've got liability, and like I said, I try to use these sort of round numbers, but you've got liability for $500,000. That's the claim. It's a $500,000 claim. You're going to settle at that $500,000, but your insurance policy has only got $100,000. $400,000 has to come from somewhere. If you've got an umbrella policy, then that $400,000 can come out of your umbrella policy. If you don't have an umbrella policy, that's a deficiency that's left, and it can come out of your business assets. And one of the things that I mentioned before is that businesses can own real property. Businesses can own personal property. If someone has a judgment against you, they can attach to all of that property. And when they attach that judgment to the property, they're essentially saying you can't sell that property without paying them back, or they can try to force the sale of the property in order to get their monies back. And so you want to put insurance out in front of the business that's out in front of you. And like I said, I would prefer that you put umbrella insurance out in front of general liability insurance, out in front of the business, out in front of you. You need to be hiding in the back or ducking down. Your goal is to stay away from getting, from any liability touching you and touching your assets. So that is one of the ways to protect your business. Another way that I always tell people to protect business is I have the saying that if it's not in writing, it didn't happen. So if you don't have a contract in place for your business relationships, if you don't have contracts in place with your vendors, if you don't have contracts in place with your independent contractors, contracts in place with your employees, then essentially you could be positioning yourself so that you've got liability. So what you want to do is put everything in writing, right? So if you got someone that's working with you or for you, and I'll say working with you, if you've got an independent contractor, and you want to make it clear that that independent contractor is not an employee, right? Because you're not taking taxes out of their monies, and you don't control how they do their work, and you don't control what it is that they wear. You know, there's all these different things that you don't necessarily have control over. You've just hired someone to perform a particular job for you. And it could be even if you had someone come in and do some consulting, right? If that person comes in and does consulting, they're not an employee of your business. They can look like an employee to IRS. One of the ways that you can show that they're not an employee is by having a good independent contractor agreement, and then by making sure that you follow the guidelines that you set in that independent contractor agreement. So you've got an agreement out there, make sure you follow it. Same thing with the bylaws, same thing with the shareholder agreement, same thing with the operating agreement. If you actually are going to put it on paper, follow what you put on paper. But if it's not in writing, it didn't happen. If that person is coming every day and they're claiming, say you decide that you no longer want to work with them, and then they seek to claim unemployment. And now you've got to try to argue to say, that was not an employee. That was a contractor providing services, but you've got nothing in writing. You've got nothing to show, right? That they were not an employee. You're going to have a hard time. And I mean, in the state of Florida, you can sue on written contracts as well as verbal contracts. Okay, breach of a written contract, you've got 5 years to file a lawsuit. Breach of a verbal contract, you've got 4 years to file a lawsuit. The only issue is what you find oftentimes is it's your word against the word of the other person, of the other party to the contract. And it's much better to say, no, listen, this is what we negotiated. This is what we drafted. This is what we both signed, instead of saying, well, I thought it was this and they thought it was that. And it was really like somewhere in the muddy middle. So contracts, right? Insurance, put the insurance out in front of you, put the insurance out in front of the business out in front of you. And then with your contracts, make sure that when you have sound contracts that have sound terms. And what I mean by that is a good contract is going to have, I say this all the time, if you've already heard it, you're hearing it again. A good contract is going to have the same elements that we had to put in our essays in elementary school. It's going to have the who, the what, the where, the when, the why, and how. At the very least, you need to know who is contracting, who are the parties to the contract. What are they contracting for? Okay. Where is performance supposed to take place? When is performance supposed to take place? Why are they contracting in the first place? And how do they intend to perform? Okay. When you have the who, what, where, when, why, and how, and you've at least written those points down, then you flesh it all out. Okay. Because sometimes your who, you might have two parties to a contract, but they might be contracting for the benefit of someone else, right? So your who gets a little different, right? You end up having more than two parties in the who place. And then what you're contracting for, you want to flesh all of that out. What is it that we're doing? What are we exchanging? For what value? What is the consideration for the contract? What monies are going to be paid? What monies won't be being paid? What are the penalties in the event that the contract is not followed? So your what becomes a little more fleshed out. When you get into when, You want to know when performance is going to take place, but what about when does the contract end? Okay. And what types of things can make that contract be terminated if it doesn't have a natural expiration? But you want to make sure that you put in there what the natural expiration is, which could be 1 year, it could be 6 months, it could be 2 years, but you want to make sure that whatever the natural expiration of that agreement is, that you have it in writing. Because some people might think that a contract is going to be perpetual, where it never ends. And others might be like, well, no, I only intended to work with you for a few months. But if you don't have any termination language in your agreement, how do you know? How does the other party know? How was there really what they call a meeting of the minds, meaning how did we agree if neither one of us knew how we were going to kind of walk away from this agreement? So make sure that you've got the who, what, where, when, why, and how in your contract language. Make sure you have contracts. You want contract, like I said, independent contractors, you want them for vendors, you want them for employees, you want them for employers. You want to be able to have contracts for services. If you are providing certain goods and or services, you want to have an agreement between you and whoever and who your client or your customer is. We call our contracts engagement agreements, at least at the law firm, where we always provide a client with an engagement agreement, letting them know what legal representation we're going to provide, what that representation is going to look like, how much they're how much they're going to pay, what happens if work goes beyond what is in that agreement, and what they would pay if we have to do something beyond what we put in the agreement. This is what you're going to want for your own clients and your own customers. If you've got a web-based business, for instance, even if you've got an e-store where you're selling products, online, selling clothing online, you want to be for there to be some sort of way where you and that buyer have an agreement as to what risk they're taking when they purchase those products. And so you want to have contracts in place. You want to have language that limits your liability. And you want to make sure that whoever you are giving that contract to sign understands the terms of that agreement. Okay. One of the big issues that a lot of people sort of come up against is, did we all understand the same thing? And I think one of the best ways to make sure that the people understand it, one, if you've got things online, you let those pop-ups keep on coming and saying, hey, have you read it? Hey, do you understand the terms? Bold letters. I have read and understand the terms of this agreement, right? Before I can get started and before I can click next, right? So you make sure that you've already placed out there, these are the terms, we understand them. If you're working with someone face-to-face, sit down and go through the contract with them. And I mean, face-to-face isn't the same that it used to be. We were living in a pandemic for I don't know how long. It seems like forever. So face-to-face might mean Zoom, right? But you can always share screen, put that contract up and go line by line. Do you understand that we're starting this contract tomorrow and that it's going to end a year from tomorrow? Oh, no, you didn't like that? Okay, well, let's change it. Let's put it down to 6 months from tomorrow. So walk through that with the other party so that you can avoid lawsuits. And again, so that you can protect your business from having, its assets attached to in the event that there is some sort of judgment or there is a settlement and some sort of deficiency. I mentioned already avoiding commingling. And I jumped into that because of the question that Brandon asked. So I think it's very important that you're careful, not only with avoiding commingling, but you need to be very careful with your accounting. Make sure that you've got checks and balances. Make sure that you know what's coming in, what's going out, that you've got your losses, your profits, and that you know these things at the very least on a monthly basis. Oftentimes we find ourselves in business not having reconciled what we've got for the month. And so we don't know what came in this month. We don't know what went out this month. We're not able to gauge or to sort of show the business growth and or when we have, because we've got those ebbs and flows. And you don't know when your valley is going to come if you're not consistently checking to see, or, checking to see what came in and what went out. Checking to see, okay, did my expenses increase this month? And if they did, why did they increase this month? It's the same thing that we do with our own lives where we should be budgeting. For instance, we know that we're going to have a higher light bill during those summer months. We live in Florida and it's hot. And so budgeting to say, okay, well, during those summer months, I know I'm going to have to put a little bit more money into, into the light bill because I'm running the AC. I'm not about to be hot. That's the same thing that you need to be able to do in business. You need to be able to plan for those times when things are going to get a little more difficult, or when expenses are going to increase, or when revenue is going to decrease, because there are times of the year that people just don't want to buy certain goods, or they can't afford certain services. And you need to be able to gauge that. The best way to do it is to make sure that you have your accounting, in order. And it's also a good way to protect yourself from failure, right? They say that a lot of businesses fail in the first few years. One of the reasons that a lot of businesses fail in the first few years is because we fail to plan. And they say if you fail to plan, you plan to fail, right? So the goal is to have good planning in order to protect your business. You want good planning. You want a good business plan at the onset, but a business plan is a living and breathing thing. So you don't just create a business plan before you have your business. You create a business plan while you're in business. You might have a plan to get started, and then you need a plan to strive, right? And then you need a plan to thrive. And then you need a plan once you've gotten started, you've been striving, you've been thriving, and now you want to bring on a new division. So you're going to have to bump down again, because there's going to be a little decrease, right, in your monies when you put out monies for that new division. And you've got to start all over with, that surviving, that, striving, that thriving, and then getting into, being successful, right? Whatever your meaning of success is, but being successful in your business, it's all about the planning. It's all about making sure that you have checks and balances in place, making sure that you have another way to protect that business is to have an advisory board, someone who you can sort of bounce your ideas for growth off of, or someone who can kind of be on the outside and look in and kind of see where you can make some changes. I believe it's important for us to audit our businesses as often as we can, so that we know where we're at and we know what we need to change. We know what we need to do, again, to protect ourselves, to protect our assets, to protect our businesses. One of the things that like I said, we practice in business, entertainment, real estate. We've got mediation services as well as a title division. Business and entertainment real estate as well have a great overlap. And one of the things that we find in overlap is intellectual property. Intellectual property is, those are the ideas, the inventions of our own minds, right? That includes patents, copyrights, trademarks, trade secrets. Okay, so trade secrets, I'll start with that one because it's the easiest one, right? It is your secret to how you do something in your business. So for instance, the KFC recipe, it's a trade secret. Somebody told it, okay? YouTube tells everything. Somebody told all those recipes. Like, I think I made the DoubleTree cookies one time because someone put that recipe out online. But the whole goal with a trade secret is to keep it secret. Don't write it down, right? Don't just give it to people. And then the other way to keep it secret is with non-disclosure agreements. So when you have employees, when you have people that you're working with, and you've got secrets, and you know that they're going to become privy to those secrets just based off of their relationship with you. When you have a non-disclosure agreement in place that says that you cannot disclose my secret, right? And then goes beyond that and says, if you do disclose my secret, then some of the recourse that I have is, one, an injunction against you, but also some monetary damage because you've now hurt my business by disclosing this secret. Then people might not be so apt to tell your trade secrets. Okay, so that's one of the easiest ones. And you can protect that with contract and with keeping that tight lip. With a trademark, which a trademark is your mark and trade. It is a source identifier. It essentially says, I want people to recognize that my goods and or services are different than the goods and services of someone else based off of this mark that I put out there. Ours is maximize your voice. We want, when people hear maximize your voice, they know that they're looking at NYV law, right? They know that it's about that business that educates, that empowers, right? That enables and that equips you to turn up the volume on your interest and to maximize your voice. That's the goal. We're supposed to be turning up the volume, right? So when people hear that source identifier, I want them to see us. I want them to recognize us as the source of certain services, of specific type of services. I don't want someone out there saying maximize your voice who's telling everybody really to be quiet. I don't want anybody out there saying maximize your voice, but I especially don't want another law firm to say maximize your voice, because again, it's not there. There will be confusion as to who is providing the services. And I don't want my services confused with someone else's. That is what a trademark is, or a service mark. It is a source identifier. And when you choose to have a source identifier and you're using it out in public and people are identifying your goods and or services by it, the way that you protect the use of that source identifier is by registering the trademark either with the state or with the United States. And that's through the United States Patent and Trademark Office in the state of Florida. It's the same, how I told you that you can go on and register your business. You can also register a trademark through Sunbiz. And so there is a fee that's charged per class of goods and or services. And when that fee is charged, beyond the fee that's charged for the class of goods and services, there's also a fee if you have an attorney to submit that application. You have attorney's fees that you'd end up having to pay. And there's a time frame that's attached to everything. With the USPTO, with federal trademarks, it used to be that you submit a trademark and within 2 to 3 months, there's an examining attorney that gets assigned to your application. They'll review the application and they'll either push that application so that it can be published for opposition, or they will issue what's called an office action. And an office action essentially says that they're going to refuse to register based on certain matters. And that might be some things are simple that they just need you to clarify some language in your application. Other times it might be that there's a likelihood of confusion. And that's what it often is that there's a likelihood of confusion with someone else's mark. And so if there's another mark that's out there that identifies someone else's goods and or services, and they are similar to your goods and or services, and that mark is similar to yours to the point that it could be confusing as to the source of the goods and or services, then an office action could be issued and they could say, we're not going to register that mark. And what you would need to do is overcome that refusal and respond to that office action within a certain period of time. If you've gotten past all the office actions, if you never had an office action and you submitted what's called a 1A application, which is an application that says, I am already using the mark in commerce, meaning I have a trademark, which mine again is maximize your voice. I am using that trademark and I'm using that trademark in my business, right? So I'm selling my services and that mark is attached to me selling those services. Something of that, when you are already using it in commerce, then you can submit the application that says you're using the mark already. And if there again are no office actions, they will submit that for opposition, to be published for opposition. When a mark is published for opposition, it's essentially the United States Patent and Trademark Office putting out to the rest of the world saying, hey, this person wants to register this mark. They want to be able to for this to be their source identifier. And if you got the same type of business or a similar business and or a similar mark, and you believe that this mark should not be registered, you better say something now. Because if you don't say it now, we're going to allow them to register the mark. And so if no one opposes the mark, then after a certain period of time that there is no opposition, then you will get that mark registered. And once the mark is registered, you can stop others from using, again, a mark similar. So I might have maximize your voice, right? And that's in English. Even if another law firm were to say maximize your voice in Spanish, then I would be, because I've registered that mark, I would be able to stop them from using the mark. Even if they weren't saying maximize your voice, if they were saying increase your voice, because it's similar, because it gives off that same commercial impression, then I could make an argument that they can't use that mark either, because it could confuse the public as to whether their legal services are my legal services. And because I registered the mark first, I'm the one that's going to be able to stop them from using it. Copyright. Copyright is a little different than trademark. Like I said, trademark is a source identifier. It's a good way to protect your business because it's all about, wanting to make sure, again, where the source of the goods and or services are coming from. And you want to protect that. You don't want to be saying, you don't want to be saying the same thing someone else is saying. For instance, if you are a fast food place and you're saying, I'm loving it, and people are getting mad because your fries don't taste like Mickey D's, that's your fault. One, you shouldn't have been using the source identifier for Mickey D's, McDonald's. But the other thing is you want to set yourself apart. You want to set your goods and services apart from other people. You want people to come to you based on your goodwill, based on the quality of your goods and their services. And then you want to be able to have a marker, something that says, hey, this is how you know who I am. This is how you know that I'm out there. So McDonald's by I'm loving it. You know about the golden arches, right? And then that color scheme, right? That's trade dress. A color scheme used for a specific business is called trade dress. So if you've got certain colors that you want people to identify, again, your goods and their services by, you can also submit an application for trade dress instead of just for a trade or service mark. Like I was saying with copyright registration is going to be for any original work of authorship fixed to a tangible medium of expression. Said all that to say, a copyright is your right to copy, right? And it essentially means that if you've created something original and someone else is able to experience it, meaning they can read it because you've written it down, they can look at it because you've created a structure, or you have you've drawn something, or it's a photograph, as long as someone else can experience it, if they can hear it, touch it, feel it, see it, then you can submit that work for copyright registration. And when you submit that work for copyright registration, then you are now limiting anyone else's ability to copy your work. So for instance, if you submitted a photograph for copyright registration, people can't just go on taking copies of that photo, you know what I'm saying, and selling copies of that photo. If you submitted music for copyright registration, same thing. And depending on what type of business you have, if you are selling, for instance, if you're selling artistic works, you might want to submit those works for copyright registration so that when you sell the work, you can then sell, right, or assign that copyright to whomever you sell it to, and they can stop people from copying, and you won't find that you've sold something of value, right, to your clients and to your customers, and it's valuable to you, but someone else is going off copying it, and they're counterfeiting what you have. So when you submit copyright registration, again, if you don't submit for copyright, for trademark registration, you can't file a lawsuit against someone and expect to win. Especially with copyright registration. Copyright registration is outright that if someone's copying your work and you've not submitted that work for copyright registration, then you will not prevail in a lawsuit. But with trademark, depending on how long you've been using the mark, you do have an opportunity. However, if you're going to sue for trademark infringement and you're suing based on the federal law, then you're going to want to make sure that you've registered your mark with the United States Patent and Trademark Office. I do not deal with patent applications. However, we do deal with agreements, and that's one of the other ways that you can protect your intellectual property. The same way you can protect your business with certain agreements, you can protect intellectual property with non-disclosure agreements. You can protect intellectual property with non-disclosure and or confidentiality agreements. They essentially say the same thing, that you agree to hold certain information confidential. But then you can also have licensing agreements. You can also assign certain rights. So if you have assignments that will still protect your rights, because if you are allowing someone else to use your work that you submitted for copyright or trademark registration, and you continue to allow other people to use them without having contracts in place that say that they can use them, how long that they can use them for, again, all of that, who, what, where, when, why, and how, then an argument can be made that you might have diluted your trademark, not just diluted it, but abandoned it, or that because you've allowed so many other people to use that mark, and anybody else who's out there and want to use it will have the opportunity to do so. So put contracts in place to protect your business, to protect your intellectual property. I'm coming to my last little section, which is the maximize your biz. So I talked about entity selection, talked about entity setup, about the organizational documents, insurance, right? Contracts, avoiding commingling, and then protecting your intellectual property. And then the last part I want to get into is not so much about, where you submit a document to, what you write down and things like that, but one part of it is, and it's building your business credit. So maximizing your maximizing your business, you want to make sure that you build up business credit. The goal of credit is to be able to leverage, right, your goodwill in order to get monies. You don't always want to use your monies, your revenue in order to make more money. Sometimes you got to use other people's money to make money. And the way that you use other people's money is by making sure that you've built your business credit to the point that people trust you to be able to give you monies. Beyond building business credit, you need to be building business relationships, right? Not just with people who are your competition, which you should be building relationship with your competition, but also build relationship with people who can help you get in front of your ideal client and or your ideal customer. Beyond those relationships, like I said, with NYB Law Firm, our goal is to educate, to empower, to enable, to equip. Get educated in your business, and then don't just be educated, be educators. When you're learning different things, when you're getting different experiences, you want to be able to build that business. And one of the best ways to build that business up, one of the best ways to maximize your business is to make sure that you leave a mark on this world that says that I didn't just learn it, but I learned it and I left a legacy to allow someone else to learn what I learned. Don't hoard information. We're not here. I mean, there is something out there for everybody. We can all get it. We can all make it. We can all be amazing. But one of the best ways for us to do that is to be able to say, hey, let me teach you what I know. Let me show you what I know. And you know what? Someone had to teach you to begin with. So it's about paying it forward. It's about trying to help others to be positioned so that they have the benefit of your education and the benefit of your experience. Make sure that you're educators. Make sure that you are out there trying to empower people, that you're trying to enable them, that you're trying to equip them, because you need that in your business. It's not just that you're trying to reach out for it, but also be able to reach out and give it back. And then the last thing that I would say in order to maximize your biz is make sure that you've got your branding on point. We're on with Brandon is our brand manager. Make sure you've got someone who's going to tell you not just what you look like, what your business looks like when you put it out there to everyone, but when you give them your vision, they can help you to execute that vision. And be consistent. Be consistent in your branding, be consistent in the excellence of the service and or the goods that you provide, be consistent in your communication with people in the community, be consistent with your business and your personal relationships, because you never know, those personal relationships can end up being business relationships. It's so crazy. It took so many years before I started seeing where the people who know me personally, because when people know you personally, they know your junk, right? But people who know me personally would be reaching out to say, hey, I need your advice on this. I want your advice on this. And when I tell you, it felt good to say, oh my gosh, my friends, my family members want what it is that I have, because they trust, right? The consistency in my relationships, the consistency in my work and my excellence, and me providing, that education, that empowerment, that enabling, that equipping. Then that is when I started feeling like I was doing something right in this world with regards to what I'm doing in my business. So in your business, you want to do what's right in the world. Make sure you get out there. Make sure you educate, you empower, you enable, you equip, and you never stop learning. If anybody has any questions for me, I'm happy to answer them. Otherwise, that's it for me.